This is Barry Zalma on insurance. Today it's time to speak about the term inception of the loss. The phrase inception of the loss in the standard fire insurance policy has been interpreted to mean the occurrence of the casualty or event insured against. The Sixth Circuit held that a 1-year limitation period after the inception of loss or damage in an insurance contract did not conflict with Kentucky law and was reasonable. The inception of loss means the time when the loss was first incurred or began to accrue. In Oregon, the Supreme Court held that the loss occurs and has its inception whether or not the insured knows of it. The phrase inception of the loss is not ambiguous and clearly denotes the time at which the loss occurred. Therefore, an insured suit on the policy will be deemed timely if it is filed within 1 year after inception of the loss, defined as that point in time when appreciable damage occurs and is or should be known to the insured, such that a reasonable insured would be aware that his notification duty under the policy has been triggered. Once any damage becomes reasonably apparent, the time begins to run, even if the full extent of the damage is unknown. The inception of the loss occurs when the insured should have known that appreciable damage had occurred, not when the homeowner learned the true extent of the damage. An insured's belated discovery of potential coverage is irrelevant to the inception of the loss date. The limitations period is told in California, that is, held in abeyance, from the time the insured gives notice of the damage to the insurer until the insurer formally denies coverage. This has been construed to mean unequivocal denial in writing. The reason for the tolling rule is to avoid penalizing the insured for the time consumed by the insurer investigating the claim, while preserving the central idea of the limitation provision that an insured will have only 12 months to institute suit. There is no requirement, however, that the insurer take firm, unmovable positions or use particular magic words, even the word deny, to achieve the requisite unconditional denial. The 12-month private limitation of action provision of first-party property policies has been upheld as valid and enforceable by every California appellate court and almost every court in every state that has been asked to consider it. Only one California court and some courts in other jurisdictions cited by it have extended the statutory 12-month limitation. Other jurisdictions apply a much more liberal interpretation, construing inception of the loss generally in terms equating the phrase with accrual of a cause of action against the insurer. However, even the Zurn court recognized the effectiveness of the private limitation of action provision and only started the running of the limitation period at a later date than the date of the actual injury. As Zurn's courts considered special facts, it liberally construed a phrase, inception of the loss, which no longer appears in current policies, to be the date when the insured is capable of presenting a proof of loss to the insurer. As will be seen in future and other decisions that we will discuss, the California Supreme Court adopted some of the analysis of the Zern Court, the history and development of the law with regard to the private limitation of action provision teaches that it should not be ignored. In 1868, the United States Supreme Court concluded that a 12-month private limitation of action provision should be strictly enforced. In Riddlesbarger v. Hartford Insurance Company, the U.S. Supreme Court in 1868 stated, quote, "It is clearly for the interest of insurance companies that the extent of losses sustained by them should be speedily ascertained, and it is equally for the interest of the assured that the loss should be speedily adjusted and paid. The conditions in policies requiring notice of the loss to be given and proofs of the amount to be furnished the insurers within certain prescribed periods must be strictly complied with to enable them to recover. And it is not an unreasonable term that in case of a controversy upon a loss, resort shall be had by the assured to the proper tribunal, whilst the transaction is recent and the proofs respecting it are ascertainable. The commencement, therefore, of the present action within the period designated was a condition essential to the plaintiff's recovery." Close quote. In 1885, the California Court of Appeal found that the 1-year private limitation to be enforceable unless the plaintiff established that negotiations with the defendant insurer established a waiver or caused the insured to be stopped from asserting the provision as a defense. Finding no evidence of waiver or evidence to support estoppel, the defense verdict was affirmed. In 1909, the California Supreme Court stated that the general rule with regard to the private limitation of action provision was, quote, "that a condition in a policy of insurance, providing that no recovery shall be had thereon unless suit be brought within a given time, is valid, if the time limited to be in itself not unreasonable." The 6-month period was not in itself unreasonable. This was Tebbets v. Fidelity and Casualty, a 1909 decision of the California Supreme Court. Basing its decision on the great weight of authority, the California Supreme Court found a period of limitation half that of the present private limitations period to be reasonable and enforceable. The primary purpose of contractual modifications of the statute of limitations is to avoid prejudice, specifically to avoid the extra danger of fraud and mistake associated with stale claims. In Estes v. Alaska Guarantee, for example, a 1989 decision, the Supreme Court of Alaska required prejudice be shown before the private limitation of action provision is applied. While in Zuckerman v. Transamerica, the Arizona Supreme Court held that a contractual modification of the statute of limitations should be enforced only when the reasons for its existence are thereby served. When enforcement does not serve the reasons for the provision's inclusion in the policy, the insured's reasonable expectation that coverage will not be arbitrarily denied must be given effect. It is a contractual undertaking between the parties to a contract of insurance that there is a limitation on the time for bringing suit imposed by the parties to the contract. Suit limitations are ubiquitous in insurance contracts. As one court stated, quote, "suit limitation clauses may represent a valid and equitable defense when pollution losses are reported on first-party policies that have long since expired. By statute, Pennsylvania law provides that contractual limitations of suit provisions, which are shorter than the applicable statute of limitations, are valid, provided they are not manifestly unreasonable. This is Calne Village Associates versus Home Indemnity, a 1999 decision of the Eastern District of Pennsylvania. When the insureds reported a leak to their carrier, the carrier's inspection disclosed mold, which the insurer paid to remediate. The insurer's inspection several months after the repairs indicated the mold remediation was effective. Subsequently, and more than a year after first reporting the leak, the homeowner sued the insurer for failing to pay for additional repairs their expert claimed were needed. The court held that summary judgment was correctly granted to the insurer based on the one-year suit limitations clause because the homeowners were on notice of the mold before the one-year deadline, and nothing limited their ability to timely file a coverage claim. In Atwood versus St. Paul, a 2006 decision of the Illinois Court of Appeal, the policyholder argued that she was entitled to the benefit of policy language in the suit limitations clause that read, quote, "If a state law provides more time, we'll conform to that law," close quote. The trial court and the appellate court agreed that state law in the insurance policy referred to insurance statutes, not general contract law. Otherwise, the one-year period would be a nullity in every state that allowed a longer period for general contract actions. In North Coast Enterprises versus St. Paul, a 2006 decision of the Western District of Washington, the insurer's investigation of the claim took nearly a year, the same length as the suit limitations clause in the policy. During the investigation, the parties frequently corresponded and exchanged information about the claim. After the claim was denied, the policyholder sued, but the suit limitation period was 5 months expired. The policyholder moved for summary judgment on the insurer's suit limitations clause defense, arguing the suit limitation period was either automatically tolled while the claim was under investigation, or equitably tolled while it waited for the insurer's denial. The court disagreed, reasoning that equitable tolling was not automatic in Washington and refused to follow the California decision in Prudential LMI versus Superior Court, a 1990 decision of the California Supreme Court. Further, the Washington court held that the insurer's correspondence with the policyholder was not intended to mislead the policyholder into letting the limitations period expire. In 1947, the U.S. Supreme Court again acknowledged the importance of the private limitation of action provision when it held with regard to fraternal benefit policy that the state of North Dakota must give full faith and credit to the shortened limitation provision in the Fraternal Society's Constitution, which was written in accordance with Ohio law, even though prohibited by South Dakota law. The California Court of Appeal, as recently as 1985, reiterated and accepted what the California Supreme Court had stated in the past, quote, "We accordingly hold that the shortened time for commencement of suit provision in the policies in question is valid and governs the time within which suit has to be commenced in this case." Close quote. This was C&H Foods versus Hartford. In addition to supporting the effectiveness of the shortened limitation of action provision, the Court of Appeal refused to allow the plaintiff to maintain a cause of action for the tort of bad faith. In doing so, it stated that in support of this contention that a bad faith action could be maintained, plaintiffs citing to Murphy versus Allstate in 1978 decision, for the proposition that even if one has lost the principal cause of action, he may still have a claim for the bad faith subsequent conduct of the insurer. Not always. While the principle is true under certain circumstances, it is of no aid to plaintiff. In the cited Murphy case, plaintiffs did not seek to hold Allstate on its policy, but for the damages caused by Allstate's conduct after the loss occurred. Allstate used contractors who did the repair and restoration of the Murphys' fire-damaged home in an unsatisfactory and unworkmanlike manner. The case at bench is distinguishable as there is no question concerning the date of accrual of the causes of action with which we are here concerned, or that the underlying causes of action were not on the policy. These factors, coupled with the failure of plaintiffs to give timely notice, the admitted destruction of the goods before the notice was given, the failure to file suit within the 1-year time for commencement of suit provision, and the allegation in the complaint adequately formed the basis upon which the trial court properly sustained the general demurs to the causes of action. Statutes of limitation are premised on two foundations. First, that a person who has a valid claim will promptly attempt to enforce a demand, and second, that after too much time has passed, by loss of evidence from death of some witnesses and the imperfect recollection of others, or the destruction of documents, it might be impossible to establish the truth. Close quote. In Sarmiento versus Grange Mutual, a 2005 decision of the Ohio Supreme Court, the court found that a 2-year contractual limitation period for filing uninsured and underinsured motorist claims is reasonable and enforceable regardless of whether the foreign state in which the accident occurred provides a longer statute of limitations for the underlying tort claim. The Ohio court relied on age-old principles that consider an insurance policy to be a contract and hold the relationship and rights of the insurer and insured to be contractual in nature. A claim for uninsured motorist coverage is therefore a contract dispute and not a tort. Concluding that the insurance contract was entered into in Ohio, issued to Maria Sarmiento, a resident of Ohio, and the covered vehicles were principally garaged in Ohio, jurisdiction to determine the effect of the contract was Ohio law. Simply stated, in Ohio, a provision in a contract may validly limit, as between the parties, the time for bringing an action to a period less than that provided by the statute of limitations. This video was adapted from my book, Zelma on Insurance Claims, Volume 4, 3rd edition, which is available as both a Kindle book, a paperback, and a hardcover from Amazon.com. If you found this video to be useful or of interest to you or your colleagues, please pass it on. It's free. And please also subscribe to my YouTube channel, my Rumble channel, my blog, and my Substack publications so that you can be advised of future videos and future blog postings. Thank you for your attention.